all stand, please. All persons having anything to do with the sitting of the Supreme Court of Tasmania draw nigh and give your attendance. Please be seated.
Alan Michael Prestage and others against Melissa Jane Barrett.
All right, well, it's not quite Groundhog Day, but the prospect of having you so close to me on the bench, Mr. Armstrong, is a bit disturbing.
I'm as large as life, Your Honour, and twice as able.
That's the point, I think. Yeah. Yes, Mr. Reid.
Yes, thank you, Your Honour. Your Honour will see that at Court Books 288, 289 and 290 are three documents upon which the defence relies in its closing.
288?
288, 289 and 290.
Mm.
Now, I won't be going at all to 288, which is our detailed written closing.
Yes, well, thank you, because subject to one question, I'm very comfortable with all of that.
Yes.
So it's 288, it's 289 the comments that have just been received on transcript references. 290 of the comments, Your Honour. 290, rather,
Yeah.
And
289
is the amended chronology.
Chronology, yes.
Yeah, okay.
Now, as to 290, Your Honour, it's not intended as an exhaustive reply because issues been joined on so many things in the written. There were just some of the matters that we felt we needed to comment upon.
Is that just an alert to me, really, not to rely unequivocally on those things?
That's the intention, thank you, Your Honour. Now, as to the chronology, Your Honour, at 289, it doesn't really need to be brought up, but it's in three colours. The first is black, and that's the plaintiff's work. The second is red, which is also the plaintiff's work, where they acknowledge there is some evidence relevant at that time, but they dispute it, and that's noted at the top. And the third is green, which are our additions.
Yeah.
Now, Your Honour, there are therefore then two things. One is the one question that Your Honour has, and the other are submissions in relation to the issue of non-delegable duty. I'm content to deal with the issue of non-delegable duty first, if that suits Your Honour.
Yes. Yes. What do you want to say about that then?
What I want to say, Your Honour, is that at page 55 of our written submissions and page 75 of the plaintiff's written submissions, that issue is dealt with.
Yeah.
Our position is that the argument advanced by the plaintiff is misconceived, and we say that because Part 9A depends on cause, not on duty.
This is the question of construction.
Yes.
How you construe the qualifying words.
Yes, yes. And so we say it's to do with cause and not duty, and you'll find that, Your Honour, by looking at section 43, capital A and capital B. It is all to do with cause. The plaintiff's argument depends upon duty. The other issue arises from paragraph 15.7 of our friend's submission, which ignores the absence of an equivalent of section 5 capital Q that's in the New South Wales Act but not in ours.
What's the point about that?
Well, it's the point about the equivalence, potential equivalence of vicarious liability and non-delegable duty.
Yes.
5Q reads, the extent of liability in tort of a person for breach of a non-delegable duty to ensure that reasonable care is taken by a person in carrying out of any work or task delegated or otherwise entrusted to the person by the defendant is to be determined as if the liability were vicarious liability of the defendant for the negligence of the person connected with the performance of the work or task. Now that isn't in our case. That in our section.
Doesn't that just beg the question of how you construe the section absent that direction?
Yeah, it does. Yes, indeed it does. Yes.
Because that makes it clear that it's for all practical purposes the same as vicarious liability.
Yes, yes.
The question is, without that, what is the nature of the liability?
That's it, and we say, Your Honour, that the facts of this case have got nothing to do with delegation. It would be different if, for example, Barrett said to Robinson once the fire was going to make sure that he was putting it out because she was having nothing to do with it. She would therefore be trying to delegate her duty to deal with the fire to Robinson. And that is something which we would concede on the construction that the plaintiffs contend for she could be liable.
But the question Mr Armstrong addresses there is the anterior question, that is, what's the nature of the non-delegable duty, absent any actual delegation?
Yes, indeed it is, Your Honour, and we say that as a matter of construction it's about cause and not duty, so we go back to that answer.
Well, you get back to Burnie Port Authority, don't you, and the points you make about that, and the points you make about what I said, which may or may not be right in Brocklands.
Yes, absolutely, that's where we go, Your Honour, yes. Now, Your Honour, if the court were to find, as pressed by our friends, that the duty is a non-delegable one, and
it's not discharged.
And it's not discharged, yes. Oh, yes, we get that it's not been discharged and it's non-delegable. Then, following the words of Justice Nettle in McLean and Meach, which is the case relied upon by our friends, Robinson took advantage of his control of the premises to carry out a dangerous activity. He decided where to light the fire, he foraged for the necessary material to start it, he set the fire, all of this without help from Barrett. He too has a non-delegable duty. So it's really a submission, what's good for the goose is good for the gander.
Just let me take that in. Does that in any way depend upon the status of his occupation of the land?
Well, it is to an extent, Your Honour. The duty, of course, arises from an occupier and not an owner. And we say that Robinson, by his use of the land, and there's abundant evidence as to how he used it, was an occupier.
So my thought might be more relevant in relation to the question of contribution and nuisance than to...
well, yes, that's definitely important in terms of contribution, Your Honour, but I'm making a slightly different point here.
Yes, you're saying that his duty is the same.
Yes. And what follows from that, Your Honour, is that we know an accord has been reached with Robinson.
Yeah.
And that accord may well be a full discharge of all liability in the case. But we don't know what's in the... I don't know at least what's in the envelope.
Well, as presently minded, I'm just not going to concern myself about that. I'm going to answer the questions, and then I'll ask counsel on the subsequent occasion to let me know or to make submissions about the nature of the orders that I should be making.
Yes. Well, Your Honour, those are the only submissions that we have, and I stand ready to answer Your Honour's question.
Well, my only question, and it may have been partially answered by the document that I saw this morning, that I think came in last night, and that you're
Excuse me, Your Honour.
Yes, Mr Armstrong.
Terribly sorry. Your Honour's, both Your Honour and Mr Reid have been breaking up for the last 40 seconds or so.
Okay.
Your Honour said something about the... I heard my friend refer to the envelope containing compromise.
Can you hear me okay now?
Perfectly, thank you.
What I said was, as presently minded, I don't propose to concern myself about what's in the envelope. I'll answer the questions in the key statements issue and indicate what my findings and conclusions would be as to the matters that are pleaded, but then to invite counsel on the subsequent occasion to make submissions as to what orders should follow, and that then might involve the opening of the envelope.
Thank you, Your Honour.
But I'll hear you about that in a moment. They're just my thoughts.
Yeah.
Thank you, Your Honour.
Well, I'm content with that course, Your Honour.
Yes. Yeah. Well, now, my question, which arose when I was reading your closing submissions, might have been answered by the document that's just been filed. And that is this, is there really a live issue as to whether the test plaintiff's property was within the fire footprint?
No, there's not. The issue is what caused the fire footprint.
Yes, okay. So well, perhaps what you said was ambiguous in your closing submissions, but it's been cleared up.
It's cleared up, Your Honour. There is no doubt that a fire came from the fire footprint as mapped at 17:35 on the 3rd and hit the test plaintiff's property.
Yeah, okay, yeah. So either I misunderstood or what you said was slightly ambiguous or slightly overconfident. But
hopefully not the latter, Your Honour.
But I thought for a terrible moment there was going to be a critical issue that might have to require us to consider reopening and
no. Once Your Honour finds that Barrett's fire caused the footprint of 1735, it's game over.
Yeah, for which there is evidence, largely uncontested, beyond Dunalley Road, beyond Gangels Road, anyway.
Yes.
Beyond Mother Brown's bonnet.
Yes. Yes, certainly. Beyond. Once it gets to Mother Brown's bonnet, you find what fire got there.
Yeah. That's
the end of the story.
Well, even then, there's some evidence as to crossing the road into the pine plantation and so on, and the blue tier or the grassy knoll or whatever it was called.
No, we're not arguing, Your Honour, that the test plaintiff is not within the final footprint.
Well, that was the only question that I had arising out of all of your submissions.
If it please, Your Honour.
Thank you. Mr. Armstrong.
Thank you, Your Honour. I was going to take a little bit longer than Mr. Reid, but that's probably going to be...
Please do. But please do understand that I've completely read and digested and have been working away on your submissions.
Yes, thank you, Your Honour. And I am going to try very hard to avoid repeating anything that I've said. I should ask as well, would Your Honour permit me to remain seated?
Yes, it's easier for everyone, thank you.
Yeah, thank you. Now, thank you, Your Honour, for the indication that you've had a chance to read our written submissions as well. I would like to begin by making some overarching comments in relation to the observations that we would invite Your Honour to make regarding the witness evidence. And in that regard, I'd like to recall to Your Honour's mind one particular moment during the trial, which by my count was on day 11, on the 13th of May, when my learned friend played the audio recording of the fire service first responders as they were travelling initially to White Hills Road and then later to Dunalley Road and eventually to Gangels Road. Your Honour, that was one of the most memorable moments of the trial in our submission, for the reason that what really impressed the listener was the calm, practical, business-like way in which the fire service first responders were exchanging information between themselves about the early course of this fire. That calmness and dispassionate exchange was evident even as Mr. Terenius was first arriving on the scene at White Hills Road, and certainly even as Constable Hall and Mr. Rainbow were putting themselves in harm's way at the end of Gangels Road, trying to work out what was happening at that location. It was frankly a little humbling for those of us who work in offices to hear the way in which the emergency services personnel were approaching the task at hand. Now, I wanted to mention that, Your Honour, because Your Honour has also had the chance over the course of the trial to observe those same first responders and other fire service personnel giving their evidence. Your Honour heard from the rest of Mr. Terenius's crew, from the Dodgers Ferry Volunteer Brigade. Your Honour heard from Mr. Butler, from the 7 Mile Brigade, and apart from Mr. Hall and Constable Hall and Mr. Skelly, Your Honour also observed the fire investigators, Mr. Bones and Mr. Walkley. In our submission, these were uniformly impressive witnesses. There was no panic or confusion in their early response to the fire, or at any time during their response to the fire. Each of them clearly had approached their task, their respective tasks, with a clear head and a clear eye, and they gave evidence to Your Honour in a very practical, straightforward, no-nonsense and disinterested way. But the defence and our learned friends are subtly and sometimes not so subtly critical of those first responder witnesses. It is said, for instance, that none of them noticed any sign of what the defence says was an entirely separate fire that had been burning for half an hour to 45 minutes, just a few hundred metres away from the Barrett property. It's said that Mr. Butler effectively was careless in his evidence when he said to Your Honour that he had seen the area of the big log and that the area around the big log had not been burned when he attended at the Barrett property on the afternoon of the 3rd of January.
Around or on either side?
On either side, Your Honour. I accept the correction. And it's put against us that, and in fact Mr. Gilmore raised the suggestion that that evidence should be regarded as evidence that relates only to a very tiny distance, measured perhaps in a few feet or even a few centimetres on either side of the big log. And that's the only area that was not burned, and Your Honour ought not draw any conclusions as to the wider area that covers what we've now been calling the septic area. And likewise, it's suggested that Mr. Butler was either careless or perhaps making it up when he gave evidence to Your Honour about his observations of having seen the burning root when he was at the property and pointing it out to Ms. Barrett on the afternoon of the 3rd of January. Then criticisms are made of Mr. Hall, sorry, Constable Hall's very considered evidence on several occasions to Your Honour when he referred to the fire at the end of Gangels Road as a spot fire. Our friends point to the Firecom audio recording, and they've set it out in their written submissions. Constable Hall there refers to the fire on at least 5 separate occasions. On only one of them does he use the word front, on none of the others, and when he gave evidence to Your Honour on 2 occasions, he was consistent that his assessment at the time had been that the fire that he found at the end of Gangels Road was a spot fire thrown by the fire near the Lawrence property. Next, our friends are suggesting that Your Honour ought to find, contrary to the evidence of Mr. Bones and Mr. Walkley, that the preliminary examination of the fire site on the 5th of January had identified the area of origin as that area near the big log or around the septic. When Mr. Bones gave evidence to Your Honour that there was only a preliminary investigation on that day, he did not tell the police that that was the area of origin, and our friend's only evidence to contradict that is the fact that the police officer, in the interview with Ms. Barrett, refers to having been told something by the fire investigators. Now, they didn't call that police officer. It's hearsay, and it was rejected by Mr. Bones. And lastly, it's suggested in our friend's written submissions that the fire investigators cut short their work on the 6th of January, not for the reasons that they gave Your Honour, but because they had a helicopter to catch. Now, the suggestion was not put in those terms to Mr. Walkley, and it was not touched on at all with Mr. Bones. In relation to Mr. Walkley, at transcript page 255, our learned friend raised the issue of needing to catch the helicopter, but did not put the allegation that we say needed to have been put, if this contention is to be raised, that the investigation had been rushed or was cut short prematurely. Now, really, Your Honour...
But that's something of a red herring, isn't it? Because helicopter or no helicopter, Mr. Walkley had reached the view that he had reached the end of what he could effectively do in the excavation.
Mr. Walkley and Mr. Bones, yes, Your Honour. But the suggestion is put, and we say really it shouldn't have been put in contentions if it hadn't been raised with the witnesses, that they had rushed their work or cut it short because of the need to leave.
Well, certainly the inference was clearly there in respect of
Mr. Walkley.
Mr. Walkley, yes.
Your Honour might find that the inference was there. In our submission, our learned friend pulled his punch and didn't put the allegation to Mr. Walkley squarely.
Yeah, well, it started going through photographs, and we found a photograph of a helicopter and so on. So.
That's right.
But, yeah, all right. Well, I can say that I'm not much impressed with that criticism.
Yeah. Now, I've dealt with the first responders, the fire service personnel, Your Honour. Can I also mention Mr. Lawrence, who's also a very important witness as things turned out. Now, Your Honour will recall that he was initially on the defendant's witness list, but we ended up calling him. And I'm sure Your Honour's assessment as well was that this was another no-nonsense witness, calm, practical. In his career, he's a manager in his workplace. He gave his evidence clearly, and Your Honour will recall that of all of the witnesses, he was, I think, the only one on the ground on the 3rd of January who had the presence of mind, even while the flames were around his house, to take photos of what was going on his mobile phone. And that's worth mentioning, Your Honour, because the defence suggests strongly, in fact they urge upon Your Honour, a conclusion to the effect that when Mr. Lawrence left his house at about 1:45 to go and visit his friend and stepped out his back door, walked westward towards his ute and got into that ute to drive north and then around to the east and back towards Inala Road, he managed to miss seeing a fire that had been burning for 20 minutes or more.
On his boundary fence.
Right on his boundary fence. And Your Honour, that's simply, we say, incredible in the true sense of the word. And lastly, an important debate in the course of the trial was the debate between the experts, Dr. Marsden Smedley on the one hand, Mr. Thomas and Mr. Gilmore for the defence on the other hand. I'll come to the defendant's experts in a moment, but in our respectful submission, Dr. Marsden Smedley was a genuinely expert, genuinely impressive expert witness who was clearly in court to assist Your Honour to try to understand various scientific considerations that affect one's assessment of the probable cause and course of this fire. He gave his evidence clearly. He was not shaken at all in cross-examination. The task was put upon him to prepare his last couple of reports in very short order in response to issues that arose in the course of the trial. And in our respectful submission, those written reports and his oral evidence were exactly what the court would expect from an expert witness. Again, independent, dispassionate, properly reasoned, and attended court for the purpose of assisting Your Honour to assess all of the other evidence and make a decision as to what had probably happened. Now, against those witnesses called by the plaintiff, I do want to say a couple of things about the defendant's witnesses. Firstly, Mr. Sutcliffe. We've addressed his evidence in great detail in our written submissions, and Your Honour, with respect, so far as it relates to questions of timing or the proposition that before 2:15 he had spent 20 to 30 minutes standing in the location he identifies, watching this bushfire, is just nonsense. Utter claptrap. Who knows what has been crossing his mind in the 8 or 9 years since the fire, but that evidence was just rubbish. On his own evidence, he would have been standing very close to and downwind of a growing forest fire for 20 or 30 minutes with a crook back, with a phone, with mobile phone coverage, fully understanding that 000 is the emergency number, yet he did nothing about it. It is, I say a fourth time, just nonsense. Mr. Thomas, our friend's first expert on the question of fire ignition, 15 months after the fire, goes out there to dig some holes looking for roots. But in circumstances where he knew that what he was likely to be needing to look for was the minute signs left by roots that had been incinerated, of which nothing was left but charcoal powder. And he took no notes. He drew a one-page sketch map, which was tendered in evidence, and then 5 years later prepared his report based simply on his memory and those photographs. And his report, as we've pointed out to Your Honour several times, in terms of the substance, reduced to 2 sentences.
2 paragraphs, 4.1 and 4.2, 4.2 and 4.3, but in any event he recanted one of them. So.
He did, Your Honour. But Your Honour's quite right, there were 2 paragraphs. I think at least one of those paragraphs was only 1 sentence long. Then Mr. Gilmore. Now, Mr. Gilmore was sent out to examine not a stump, but the memory of a stump. Your Honour knows it had been ripped out and cut up 4 years earlier. Nobody had told Your Honour about that in Mr. Gilmore's reports or before he came to give his evidence. No one had told him about that work that had been undertaken by the RACT. But very importantly for present purposes, nor did he ask. It was put to him how different the site appeared when he attended compared to what was shown in the TFS and police photographs from January 2013. And he didn't ask any questions about what had happened to cause the site to look so different. After his excavation, he was told about the Thomas excavation that had been undertaken in March and April 2014. But it wasn't until cross-examination that he learned about the work that was done by the RACT. Now, Your Honour, given the evidence both from Mr. Thomas and from Mr. Gilmore regarding the likelihood that the roots, if allowed to burn for some days, would very likely have incinerated down to the level of charcoal powder with perhaps a few pieces of solid charcoal dotted around, and the likelihood that the tunnels that were left around those roots in soft, loose soil would have collapsed if there had been other disturbance to the site. In our submission, the site had been hopelessly compromised by all of the work that had been done to it since January 2013. There had been the initial excavation by the TFS, the further excavation by Mr. Thomas. The dog had been buried there. The tree had grown up. Fire trucks and other vehicles had driven past the area. And ultimately the RACT had gone out there with heavy machinery to do what even Mr. Gilmore agreed would have been a very violent act requiring significant force to rip out the tree stump. Now, I'll come back to one issue of the evidence regarding the work that was done by RSCT later on. In our submission, it's clear that Mr. Gilmore's brief was not to review dispassionately the evidence that had been found by the TFS, but rather to look for signs of burning in other stumps. The excavation work that he did was so limited and, most importantly, so shallow that it was utterly incapable of telling Your Honour anything about the veracity of the conclusions that had been reached by the TFS.
Well, at the end of the day, he accepted in answer to a question that I asked that he was not in any way intending to follow.
I'm sorry, Your Honour's broken.
Yes, I'm sorry, it's my fault. I'm moving away from the microphone. At the end of the day, in answer to a question that I asked of him, he accepted that he wasn't in any way intending to or purporting to follow the path that Mr. Walkley had followed.
That's right, Your Honour. And so his report, his conclusions, the fact that he found some signs of burning in a couple of other pieces of wood that he detected around the new sapling goes nowhere. It doesn't challenge, doesn't contradict the TFS evidence at all. And in relation to those other pieces of wood that he found, Your Honour will recall as well that when he was taken to the comparison between Mr. Thomas's photograph 13 and Mr. Gilmore's own photographs showing the excavations that he'd undertaken.
Well, they certainly didn't appear to align.
It certainly did not, Your Honour. And apart from the angle of approach to the stump, it didn't seem to be the same, but even the stump that Mr. Gilmore himself photographed did not sit together with, it sat next to some other roots that were not apparent in any of Mr. Thomas's photographs, but would have been apparent if they were the same stump. And then his evidence as to the information that Mr. Gilmore was able to glean from the 2013 photographs in our submission likewise was wholly unpersuasive. There was the photograph that we referred to a few times as the chickenpox photograph, the up-close one where Mr. Gilmore, in the course of his evidence in chief, circled 7 or 8 different tiny micro indicators. It took a long time in his evidence in chief, but ultimately he conceded in cross-examination that that photograph actually told him nothing about fire direction. All it was a photograph of an area of confusion. Likewise, figures 5 and 20 in his report, he ultimately agreed, gave him no reliable information about the direction of fire travel.
Just remind me, did that chickenpox photograph include the cupping marks on the 2 sags, or
on the 2 tussocks?
on 2 tussocks, yeah.
No, that was the photographs of the tussocks, Your Honour, were in, I think, document 101 at photograph 6.
Right, thank you.
Perhaps if I was going to say if Mr. Temponi could bring it up, but we don't have Mr. Temponi in that role.
No, I think I've got it. I'm just trying to visualize. Well, I certainly can visualise the. Incidentally, we call them sags. As a kid, they were always sags, not tussocks. But I can certainly visualise the two tussocks and the analysis of them. But I was just trying to think what else was included in the chickenpox photograph. That was all.
The chickenpox photograph was the up-close photograph of the area around marker 20.
Yeah.
And there were a few rocks.
Staining.
A little bit of staining on these quite small rocks. And then lots of circles in red drawn by Mr. Gilmore indicating various things that he was referring to in his evidence. I'm told, Your Honour, it's Court Book 208 is the chickenpox photograph.
All right. Well, we'll have a look at it.
Now, the other point to make about the marker 20 issue in Mr. Gilmore, Your Honour, was, again, I say this advisedly, the nonsense that we heard about marker 20 actually showing the site of a wholly separate stump that had been burned by the bushfire and that on Mr. Gilmore's evidence had kept burning right through the afternoon of the 3rd of January.
Well, now this is it. This is what I was thinking too. This is it. Can you see the photograph that's on the screen now?
I can, Your Honour, thank you.
Yeah. Well, that's in the centre bottom portion of that photograph is the area he is talking about, and perhaps the rock that's marked X as being a rock that had fallen in.
Perhaps, yes, Your Honour. Now, this suggestion that there was a burning stump sitting there a few metres north of the old stump right through the afternoon of the 3rd of January, while the TFS crews, and I think there were ultimately 2 crews in attendance at the property during the afternoon, and none of them noticed it or did anything about it or referred to it. And it was not suggested to any of the witnesses, certainly not suggested to Mr. Butler.
Well, while Mr. Butler was talking to Ms. Barrett.
That's right. On Mr. Gilmore's theory, Mr. Butler was crouching next to the old stump, pointing out the burning route to Ms. Barrett, while there was this, what I call Gilmore stump, happily burning away about 2.5 or 3 metres immediately to the north. It is just not credible evidence. And lastly, in relation to Mr. Gilmore, Your Honour will recall, for example, his quite discreditable obtuseness in the debates about what the fire spotters down at Eaglehawk Neck would have seen on the question of whether there was 1 fire or 2. He was determined not to answer those questions until ultimately forced to concede that there was no material change in visibility between 1:30 and 2:15, and a fire spotter who saw the early wisps of smoke from the Barrett fire at 2:15 would inevitably have seen a much larger volume of smoke that would have been rising from at least half an hour earlier if Mr. Sutcliffe's evidence were accurate. So, Your Honour, the defendant's expert evidence in our submission ultimately is of no assistance to you. It comes back to this question of the test that the plaintiffs face in a circumstantial case. It is not enough for the defendant to throw up wild possibilities without a skerrick of plausible supporting evidence and then rely upon that idle speculation to make a contention that the plaintiff has not discharged its burden of care, its burden of proof. Now, I want to say a little bit more about that issue of the circumstantial case. Our learned friends based the first part of their submissions on some propositions advanced by Mr. Holmes. Now, the name of Holmes is revered in the law, Your Honour, but we tend to prefer Oliver Wendell, not Sherlock. And our learned friends quote Sherlock Holmes for the proposition, how often have I said to you that when you have eliminated the impossible, whatever remains, however improbable, must be the truth. There are a couple of answers to that, Your Honour. Firstly, can I offer an alternative quote from Oliver Wendell Holmes? That is, truth is tough. It will not break like a bubble at a touch. Nay, you may kick it about all day like a football, and it will be round and full at evening. His Honour...
How long did it take you to find that?
About 2 minutes, Your Honour. Now, we say that that observation from Justice Holmes aptly describes the evidence before Your Honour. The ignition mechanism that was determined by the fire investigators is a well-known phenomenon that is consistent with all the recoverable underground evidence and all of the witness evidence as to fire location and movement. The narrative advanced by the plaintiffs is the only one consistent with all the evidence. And in our submission, there is a lot of evidence affirmatively supporting every element of that narrative. On the other hand, the defence offers no plausible alternative explanation for the ignition of the fire on the Barrett property. And the evidence I just referred to, no plausible evidence, so far as they rely upon any evidence, they rely upon the Sutcliffe fire theory, or what we've referred to in our written submissions as the number 3 fire. In the case of Mr. Sutcliffe, it is demonstrably nonsense. And in the case of the number 3 fire theory, it is much more plausibly explained as a spot fire thrown from the fire that we say was ignited. And so we say, Your Honour, that is an example of Justice Holmes' perspicacity. No matter how you look at the evidence, it all comes back to aligning with the plaintiff's allegations as to how the fire started and where it went. When Your Honour, on the other hand, looks at the defendant's evidence, none of it is explained by the observations of the impartial witnesses, and most of it is simply not credible. And then finally, responding to Sherlock Holmes, it is not the case here that the contentions advanced by the plaintiff are at all improbable. On the other hand, sorry, I should say, on the contrary, the explanation advanced by the plaintiffs reflects a well-known phenomenon, the risk of which is recognised in Tasmanian legislation. Now, we've referred in our written submissions to the decision of the full court in Langmaid. In our respectful submission, our synthesis as to the principles to be extracted from Langmaid that we set out in paragraphs 2.2 and 2.3 of our submissions are accurate and are an answer to the defendant's really entire approach to this case. The plaintiffs are only held to the civil standard of care. In our submission, we've discharged the burden of demonstrating upon the balance of probabilities that the fire started in the way for which we contend, and the fact that in theory it is possible that there might have been other causes is not an answer when there is no plausible evidence or affirmative evidence to show that any of those other causes in fact operated. And so when our learned friends at paragraph 19 referred to the observations of Lord Brandon in
Razor shipping.
That's Razor shipping, yes, Your Honour. Those observations that they cite at paragraph 19 only have work to do if and when the plaintiff has not discharged its own burden of proof. We say we've done everything that is established as required in Langmaid and the cases that it cites. All of the evidence points to the correctness of the plaintiff's allegations. Now, can I move to some of the specific matters raised by the defence in their closing submissions? I can move through this quite quickly. Firstly, on the first causation question of whether the fire service investigators were correct in their assessment of the area of origin, in paragraph 37 of our friends' submissions, we say that they give a quite wrong account of the evidence. The screenshot that appears at paragraph, or just before paragraph 53 of our learned friends' submissions is a cutout or a snapshot of the screenshot initially prepared by Mr. Robinson, and the yellow lines are the ones that show Mr. Robinson's observations as to the apparent area of origin and early process of movement of the fire. Now, our friends have taken the issue several times that Mr. Robinson was asked to give his impressions. That's not quite right, Your Honour. The main question that led to this, the preparation of this screenshot, had referred to his observations. That's at transcript 636 of line 16. The only thing that was an impression was the lines and the arrows, because of course it can only be an impression. He's only trying to indicate where he saw the fire moving. The alternative would be some construction to suggest that the fire moved exactly along the lines of, and only along the lines of, the yellow markings, and that's clearly not the case. Our friends then go on to talk about, make some observations as to the expert evidence. We've addressed that in our written submissions, and I won't repeat what we've otherwise said. At paragraph 56, our learned friends say that Mr. Walkley did not give evidence regarding the direction of fire travel across the septic area. We think that is wrong. We'd refer, Your Honour, to transcript page 235 at lines 33 to 41. We say that Mr. Walkley's evidence was that the fire came up over the septic area from the gully, not from the other way around, and then spread across the grassed area. Then our friends at paragraph 57 seem to make some criticism of Mr. Walkley on the basis that he was not able to point to any fire language within the TFS area of origin consistent with the fire starting in the vicinity of the stump and moving east. Now, Mr. Walkley was firm in his evidence that the fire started within that area of origin, but equally firm that the area that had been marked off with the tape was marked in that way because it was the area of confusion, where the fire in its early stages was, to use Mr. Bones' language, stooging around as a low-intensity fire, protected in part by small rocks from the wind and looking for the small patches of fuel that enabled it to continue burning. Then at paragraphs 58 to 60, our friends addressed the question of what Your Honour described as the sag or the tussock. In our respectful submission, Dr. Marsden Smedley's explanation for those burn patterns made a lot more sense than the explanation provided by other witnesses, namely that a low-intensity fire crept into the clump of each sag from one side, burned as a low-intensity fire through the side where the fronds were still standing, and then was protected by those fronds and able to burn the entirety of the downwind side of the sag because the wind was blowing it away from the fronds that were still standing. Lastly, in this regard, our friends at paragraph 66 make a great deal of play of the fact that Dr. Marsden Smedley identified one waypoint on his GPS system that suggested a direction of fire travel that was east-northeast rather than east or southeast. That was only one waypoint that was angled slightly differently to what might have been predicted. But when Your Honour looks at the list or the full set of waypoints that appears at paragraph 67 of our learned friends submissions, if our learned friends are correct, then on the other hand there would be 6 or 7 waypoints that are not at all explained by their theory as to the area of fire ignition. Those would be waypoints 3, 14, 15, 16, 20 and 19, which would all be too far north for the fire if it had ignited at the area south of the big log. Then in relation to the second causation question raised by our friends, namely whether the campfire ignited the bushfire, again, there's only a few points I want to make. I've already addressed the issue of whether the fire scene investigators were rushed. I've already addressed the implication that appears to arise at paragraph 117 of our friend's submissions that Mr. Butler was making it up when he gave evidence to Your Honour about the burning route that he observed on the 3rd of January. At paragraph 129, our friends refer to Mr. Jackson's expert report, and they treat the photograph that appears at paragraph 129 as if it were itself evidence that the route that had been identified by the fire scene investigators had been connected to either of the stumps that are circled in yellow. Now,
is this MG11, MG11, is it?
No, it's in our learned friends submissions. If I could perhaps trouble you on
no, the photograph, I mean, yeah.
The photograph that I'm referring to again is reproduced in our friends submissions at paragraph or page 31 at paragraph 129.
You just scroll down a bit. Oh yes, I see. No, I had in mind that that was a screenshot from Mr. Gilmore's evidence, which was marked MG11, but it's okay. I now know what you mean.
And as we pointed out at the time.
Scroll down a bit further. Well, yep, thank you. Yes, thanks.
And this, Your Honour will recall, is the photograph that was used in contrast to Mr. Gilmore's own photographs of the stump that he excavated, to make the point that what he excavated doesn't seem to bear any resemblance to what we see in the yellow circled areas of this photograph. We also made the point that looking at the angle of approach, it seemed that the TFS excavation was over to the right of this area that had been dug out by Mr. Thomas. I don't need to say anything further about Mr. Gilmore. It's addressed at the points that are made at paragraph 138. Well, I will say this. Our friends make a virtue of Mr. Gilmore maintaining his opinion. But given the propositions of matters that were put to Mr. Gilmore about the shallowness of his excavations and the location of his excavations, in our respectful submission, his work did not provide a basis for the bold assertions that were recorded in his written report. And he ought to have retracted them. Or never to have made them, actually. At paragraph 145, our friends again refer to Mr. Gilmore. But we say in relation to that, Your Honour, that even Mr. Gilmore accepted the fire scene investigators' report that the stump itself had still been warm on the 6th of January. And there was no evidence from anyone that the bushfire itself had ever passed back across the stump. So in our submission, its continued warmth on the 6th of January was entirely consistent with it having been burning since the 28th of December. There was continuing combustion within the structure since the 28th of December. Now, can I turn to the question of duty and some of the legal issues? This is raised by our learned friends at, firstly dealing with the question of risk of harm that's raised by our learned friends at paragraph 159 and following. For Your Honour's reference, the same issue is addressed in our submissions at paragraphs 13.19 and following. Now, the difference between the parties as to the risk of harm in our submission can be approached in this way. Firstly, the risk of harm can be articulated at three potential levels. At the broad level, it could be described as the risk of harm associated with the ignition of fire on the Barratt property. At the second level, slightly more specific, it could be the risk of harm associated with the lighting of a campfire in the tree stump on the Barratt property. Or at a third level, most specific, it might be said to be the risk of harm, damage caused by bushfire, resulting from the escape of fire caused by a campfire in the tree stump having been lit in the conditions of the 28th of December or at any time up until the 3rd of January. And perhaps even further, our friends would say that it needs to contemplate the risk so far as it's limited to the mechanism of a smouldering burn in the root system. Now, Your Honour, we say that the relevant risk of harm is at the first or second level that I just outlined. That is, the risk that lighting a fire on the property in summertime in that area could lead to a bushfire is the appropriate articulation of the risk, because that's the risk that informs a person's decision whether to light the fire or light a fire anywhere on the property at all.
Well, if you don't state it at that high level of abstraction, you risk confusing the risk with the consequences.
I'm sorry, Your Honour, broke up at confusion.
If you don't state the risk at that higher level of abstraction, then you risk confusing the risk with the consequences.
Exactly so, Your Honour.
Very much
Yes.
what Justice Hayne used to be on about when framing duty.
Yes, yes, exactly so. And really the reason for that, the reason why that must be correct, is because the risk expressed at that broad level is the one that then guides a person's actions. They decide whether to light a fire at all, and if so, where they light it. And so that's the articulation of the risk that should inform people's decisions as to what they then do. Now, it seems to us, considering our learned friends' submissions, that the way in which they seek to articulate the risk in paragraph 159 of their submissions is an attempt to downplay the significance of the statutory regime that we've sought to emphasise. And there are 3 points that we want to make in that regard. Firstly, our learned friends are quite correct when they say at paragraph 164 that this is not a case where we're alleging a breach of a statutory duty. Of course, as Your Honour is well aware, our point is simply that the statutory obligation informs the common law duty, or informs the court's assessment of the common law duty. Secondly, again, turning to paragraph 164 of our friends' submissions, they make the point that their point is at paragraph 163. They say that the fire was lit at night outside any period of fire warning or ban. But that's not correct, as Your Honour now knows. The fire was lit in breach of the requirements of section 69 of the Fire Services Act. either in breach of section 69 subsection 2, that is, it was in a tree stump, or at the very least in breach of subsection 4 because it was lit within 3 metres of other flammable material, namely the rest of the stump. We say, Your Honour, that the operation of those subsections in section 69 is to the effect that the fire must never be lit during the fire service period within 3 metres of a tree stump, and never during the fire ban period be lit for warmth within 3 metres of flammable material. Now, in response to that, our friends seem to now raise the surprising contention that this fire was not prohibited by section 69 because it was lit for ambience or the amusement of a child, and that is somehow legally different from a fire lit for warmth. In our submission, that is, with respect, utterly spurious distinction, and Your Honour would not countenance it. But more importantly, it is wholly controverted by their own evidence. Mr. Robinson referred to having lit the fire for warmth, both in his interview at the police station, Court Book Document 54, page 0135 at about point 2 of the page, and in his evidence to Your Honour at transcript page 629 at line 10. Ms. Barrett, in her evidence to Your Honour, referred to having been cold. That's at transcript page 440 line 21. But most conclusively, Ms. Barrett, in her response to the police questions at the interview at the Sorrel station, transcript at document 52, page 80 of that transcript at line 17, told the police that little Lockie wanted the fire so that they could keep warm. That is, quote unquote, can we just have a little fire to keep warm, close quote. So it's clear from Ms. Barrett's and Mr. Robinson's evidence that this was a fire lit for warmth. And that's the end of the cute distinction between a fire lit for ambience and a fire lit for warmth. It's not a distinction that Your Honour would give credence to, and in any event, it's not made out on the evidence. Now, in terms of the significance of the statutory obligation, we've addressed that in detail, in particular at paragraph 13.36 and following of our submissions. As we've sought to make clear, in our contention, the statutory provisions reflect a legislative expression of what risks are foreseeable, of what risks are sufficiently significant that they require some action in response, and a legislative expression of what a reasonable person would do in response to those risks, namely, not light a fire in a tree stump, and certainly not in summertime. Coherence between the statute and the common law compels a conclusion that it is not reasonable conduct for common law purposes to do something that a statute does not merely prohibit, but further sanctions with a fine. We've referred in our written submissions to Adil's Palace, Your Honour. I don't want to go over anything that we've said there, only to make this additional point.
That you don't put the cart before the horse.
You don't put the cart before the horse, that's quite right. But also that the court there made the observation that the the venue operator in that case, there was a quid pro quo, as it were, that in return for the license to host events like that and to serve alcohol, namely the privilege, there was the price to be paid of having to ensure that the venue was safe and secure and that the rules around responsible service of alcohol were followed. Now, that notion of quid pro quo might apply if Section 69, subsection 4, were the only provision engaged in the present case. But we've already said that in our submission it's not. And Section 69, subsection 2, is actually a much easier proposition for Your Honour, because it's just a flat prohibition on lighting fires in tree stumps. There's nothing about quid pro quo involved. It's not that you get to light a fire in certain conditions if you do other things. The Act says, thou shalt not light a fire in a tree stump. Now, our friends say at paragraph 168 that they lit the fire in a cleared area. Well, that may be accepted. There had been clearance work done around the tree stump, but the problem is they still lit the fire within the tree stump, too close to flammable material. And finally, on this question, our friends at paragraph 177 say that the precaution of doing the additional things that the plaintiffs identify was not necessary in order to discharge the defendant's duty of care, given the rain they say fell on the days following and the various other precautions that they took. Now, in our respectful submission, that's not correct. Firstly, because this was, long story short, an illegal fire. It should not have been lit. Secondly, the other precautions were either non-existent or perfunctory. Mr. Robinson did not kick soil over the coals to put them out. He kicked soil over simply to ensure that they didn't blow away overnight, for the obvious reason that if they did, they'd still be burning. So he expected that the coals would continue burning at least overnight. And the evidence regarding Ms. Barrett's efforts to put out the fire involved a couple of half buckets of water and then nothing after that. She didn't even check the fire the next morning, and in response to her observations of steam, she did nothing more than go over and do a visual glance at the stump and observe that what she could see seemed to be wet. And lastly, on this point, Your Honour, the timing of the rain, as Your Honour will recall from the course of the evidence at the trial, is a matter of controversy. Mr. Robinson did not say that there was rain on the 29th of December. The transcript at page 630 falls well short of him saying that there was rain the next morning. He said that there was rain over the course of a couple of days, and Your Honour will recall that he was there until the 2nd of January. It's not controversial, as we understand it, that there was rain on the 1st and 2nd of January, but that's different from the 29th of December. Can I turn to the third causation question that our friends start to address at paragraph 181? This is the question of the Sutcliffe fire and perhaps also the number 3 fire. Now, this is a bit like Monty Python's Black Knight. We're not sure how many flesh wounds this implausible notion has to suffer before they give up, but unfortunately we still need to deal with Mr. Sutcliffe's evidence. I don't want to say anything further to what I've said earlier today or what we've put out in our written submissions. I just want to correct a couple of things that are, we say, not correct in our friend's written submission. Paragraph 184, Your Honour, all of the points there, we say, with respect, actually support the plaintiff's narrative as to what happened. At paragraph 184D, our friends say that at around 3:15, Mr. Terenius gave evidence to the effect that the fire had burnt past the Lawrence property and was heading southeast towards Gangels Road. Now, the reference to southeast towards Gangels Road is, I think, a reference to Mr. Terenius's observations from an earlier time when he was still at
244. Yes, that's the way I understood.
That's right. And in any event, as at 3:15, Your Honour will recall Mr. Lawrence gave evidence that the fire had hit his western boundary at about 3:10. So when Your Honour keeps that timing in mind, the fact that the fire was moving under a strong westerly wind, having hit Mr. Lawrence's boundary, it was then moving through that strip of woodland to the north of his property and then moving further east, plus the consideration that Constable Hall had identified the spot fires on the hill to the east of the Lawrence property. There's actually nothing inconsistent between the account of Mr. Terenius's evidence that's recorded in paragraph 184D and the allegations made by the plaintiff. By 3:15, there was fire to the east of the Lawrence property, certainly at least the spot fire identified by Constable Hall. And by 3:15, the fire front had already hit Mr. Lawrence's western boundary and was continuing to move towards the east. Paragraph 197, the suggestion seems to be that Warmby's Creek is to the west of Mr. Lawrence's property. That's not correct, Your Honour. The Warmby's Creek area
It's to the north.
to the north and east of the Lawrence property. And in fact, so much seems to be recognised by our friends at paragraph 207, where they do refer to Warmby's Creek as being, they refer to Warmby's Creek as being east of 244 Whitehills Road. But in any event, the evidence is that it's it's northeast of the Lawrence property. I've already referred to the issue regarding Constable Hall's audio recording to the TFS and the one reference to a fire front. And Your Honour saw Constable Hall on a couple of occasions and had an opportunity to assess the likely veracity of his evidence at the trial that what he saw at Gangels Road was not a spot fire. At paragraph 217, again, our friends fixate upon a single piece of evidence that they attribute to Miss Constable Hall. That is that the FireCom call log, the written record of the fire communications, records Constable Hall as saying that the wind when he was at Gangels Road was southwesterly. Now, that's not the audio recording. It's what's been typed by a FireCom's operator. Constable Hall's oral evidence was that, and was consistently, that the wind was westerly. The Bureau of Meteorology data is that the wind was westerly, and every other witness referred to the wind as westerly or west-northwesterly. Then continuing with the issue of spotting that's addressed by our friends from paragraph 217 and following, I referred earlier to the fact that Dr. Marsden Smedley's last couple of reports needed to be prepared in response to the emerging case from the defendant that, in fact, there had been a separate fire ignited by circumstances unknown but unrelated to the Barrett fire, and had been ignited either at the location identified as marker 3A on photograph at Court Book 150, or possibly even at the Gangel's Road site that was identified as marker 3B at Court Book 150. Dr. Marsden Smedley then prepared his last report that specifically dealt with the issue of spotting rather than the fire front. Mr. Gilmore, by comparison, was not an expert in bushfire prediction, was not an expert in bushfire modelling, and even allowing for those obvious limitations on Mr. Gilmore's expertise, his only reservation in response to Dr. Marsden Smedley's assessment of the likelihood of spotting in the general area around marker 3A was that Mr. Gilmore thought that there was one area to the north of marker 3A that seemed to him to be too far northeast to be explained by spotting given the westerly wind. But Mr. Gilmore also acknowledged that spotting is slightly random. It's affected by particular gusts of wind, and that wind currents are distorted by the convection effect of a large bushfire and by physical features like the presence of hills and gullies, and Your Honour has seen that there are plenty of them around. And so the fact that the one area where the fire direction suggested that there might have been some spotting slightly further north of an area that Mr. Gilmore would have expected is nothing like enough to suggest that there was a wholly independent cause of fire that ignited at that area that Mr. Gilmore identified. Our friends at paragraph 224, subparagraph D, say that the paragraph refers to Mr. Terenius's evidence that there was crowning in the area of 242-244 Whitehill Road at 2:30 p.m. They say that Mr. Terenius gave no specificity as to when he made this observation. And that's quite wrong. Mr. Terenius made it clear that he was describing the observations he made while he was at 244 Whitehills Road, and he was only there from about 2:30 or 2:35 until I think about 2:50.
And the plausibility of that evidence is confirmed by Dr. Marsden Smedley as well. So.
That's right, and indeed, Your Honour, it's actually confirmed by Mr. Gilmore. Your Honour will recall that Mr. Gilmore identified the area where he thought that crowning would have either occurred or a person might have thought that they were seeing crowning when they saw flames coming through the trees. And the green triangle area that Mr. Gilmore drew on the screenshot was only very, very slightly further east from the area that Dr. Marsden Smedley had estimated. So allowing for all of the vagaries of wind and fire travel and fuel loads and what have you, there was actually quite a lot of alignment between the eastern boundary of Dr. Marsden Smedley's fire area and the western boundary of the area where Mr. Gilmore thought that there would have been crowning by 2:45 or 3 p.m. Next, in relation to the question of the fire area or the footprint, given Your Honour's exchange with my learned friend a moment ago, I don't think we need to deal with that any further. It's certainly, just for Your Honour's reference, perhaps I'll mention that the critical paragraphs in Dr. Marsden Smedley's first report as to the way in which his maps were prepared are paragraphs 3.2.2.11 and through to point 14. The maps were all the product of the line scan data and the field reports as to the fire location that had been called in during the course of the fire. There were 3 maps that he identifies at 3.2.2.11 that were intermediate in the sense that they were prepared by Dr. Marsden-Smedley to address what he thought would have been the fire footprint at times between the points when there was available line scan data. And when he needed to fill in a gap of, gaps were only ever a couple of hours, then he took the preceding line scan and field report data and the later line scan and field report data, but for the interval used his fire prediction model to work out where the fire would have been at a given intermediate point. None of those estimates affected the ultimate final footprint, which he explains at 3.2.2.14 was prepared from a high definition aerial photograph. Last couple of topics. Firstly, on the issue of the non-delegable duty that our friends addressed at paragraph 245 and following. The proposition against us, Your Honour, is that non-delegable duties arise from relationships. The relevant categories of relationship might not be closed, but they are confined. But the relationship with which Your Honour is concerned in this case should be described simply as one of friendship, and that friendship is not a recognised relationship for the purposes of non-delegable duties. Now, our response, Your Honour, is that that's a wrong characterisation of the relevant relationship. Law does not look to the emotional connection like that. It looks rather at the legal status of the parties to the relationship, and I think that this is the point that Your Honour was adverting to. The relevant status here, the relevant relationship, is simply that of an occupier on the one hand and an invitee or perhaps a licensee on the other hand. Ms. Barrett, the circumstance that Ms. Barrett and Mr. Robinson were friends or were in any other kind of relationship at the time of the fire is not to the point. What matters is that there was an occupier and an invitee. To look at something like the nature of the friendship would be like saying that the relevant relationship in Burnie Ports and that the propositions established by Burnie Ports only apply as between oxy welders and the wholesalers of frozen peas. It's simply not the right way to characterise it. Moreover, Your Honour, it's just too simplistic to say that the imposition of a non-delegable duty depends on relationships. McLean and Meach makes clear that it depends on circumstances. And here, the relevant circumstance is that Ms. Barrett, as the occupier and as the host of Mr. Robinson and his son, was in a position to tell them not to do things on her property. And in circumstances where she allowed them to light a fire, she remained under a continuing personal duty, not simply to take care as to her own conduct, but also to exercise herself to ensure, I'll avoid using ensure, to take reasonable care to bring about Mr. Robinson being careful as to how he dealt with the fire that had been lit. I avoided ensure there because, as we've said in our written submissions, we accept that Ms. Barrett's obligation was only to take reasonable care as to her, shall we say, supervision of Mr. Robinson. It's not strict liability in that sense. And in relation to Your Honour's observations in Brocklands, that was referred to a little earlier as well, and I referred to it our friend's submissions at paragraph 172. For the reason that I just mentioned, we don't contend, and we've never contended, that the imposition of a non-delegable duty amounts to any kind of a guarantee. It's only an obligation on Ms. Barrett to take reasonable care to ensure, and I've already qualified my reference to ensure, that it's only an obligation on her to ensure, to take reasonable care to ensure that Mr. Robinson took reasonable care in his management of the fire. The evidence, however, shows that she did virtually nothing. He kicked the soil over the coals. She poured some water onto the fire, but she did nothing in the days after to check whether Mr. Robinson had done anything further to be properly and safely sure that the fire was completely out and there was no continuing combustion in the tree stump. We've referred as well in our written submissions, Your Honour, to the evidence that Ms. Barrett gave to the police that on prior occasions when fires had been lit for the purpose of burning off rubbish in the tree stump, the fire had continued, she had observed that in the days after the fire was thought to be out, there was still steam occasionally rising from the area of the stump, and when she poured water into it, she would see it bubble and sizzle. Those were her words. Now, she said in her evidence to Your Honour that what she meant there was simply that when there were burning leaves and what have you left in the tree stump, they'd continue to steam. Now, we would respectfully urge Your Honour to conclude that the statement that she gave to the police was not on any fair construction limited in that way. The phenomenon she was describing was having lit a fire in the tree stump, thought it was out, then observing in the days after that there were still signs of smoke or steam or something arising from the stump, and when she went over on those occasions and poured more water in, there was bubbling and sizzling as the water hit the coals. Sign that fires, when they were lit in this tree stump, were very hard to put out. They continued to burn for days. We've also addressed in our written submissions, Your Honour, the interesting issue regarding the way the apportionment provisions apply in our submission where there's a case of non-delegable duty. I don't think I can usefully add anything to what we've written. Now, lastly, Your Honour, on the question of nuisance, looking at paragraphs 260 to 265 of our friend's submission, the parties seem to be in agreement that liability in nuisance does depend on some conception of fault, and moreover that the fault element is simple foreseeability. Our friend's formulation of the test for liability in nuisance that appears at paragraph 266 of their submissions seems to align quite closely with ours at paragraph 16.29. The difference appears to be that our friends say that the harm must have been reasonably foreseeable as a likely consequence of the activity, whereas we say that the harm must have been reasonably foreseeable as a potential consequence. In our submission, the proper test is the one that we have articulated. It's foreseeability of the risk, not the likelihood. And that must be the case as a matter of logic. Otherwise, nuisance would become and be limited to as a tort that only was engaged where there were cases of effectively intentional harm. Doing something knowing that there was a likely impact on one's neighbours in the general sense, rather than doing something or allowing something to be done with reasonable foreseeability of a real risk of an impact. on one's neighbours. And looking at the authorities, most recently, Her Honour Justice Richards in Butler Market Gardens that we've cited in their written submissions at paragraph 99, adopts the test that it's sufficient that the person accused of the nuisance, that it was reasonably foreseeable to the person accused of the nuisance that it might lead to a foreseeable harm. And we say that is the right test because it's not a tort that only relates to the intentional infliction of harm. And again, we've addressed the operation of the apportionment provisions and the contribution provisions in our written submissions. The last matter that I wanted to address overall, Your Honour, is a couple of issues arising from the documents that were uploaded to the court book, I think either last night or this morning, which were documents 288, 289 and 290. 289 is the updated chronology with our friends' comments in green. I don't need to deal with any of those except the entry for 15 September 2014, where our friends have made the amendment to the chronology to say that no tree roots below ground level were excavated, and they give a document reference there. Now, Your Honour, the document that they cite there was not tendered. The only tender from the bundle of documents that was at Court Book 155 was the photograph of the site of the stump after the RACT had done their work. And the exhibit list makes clear and has made clear for some 10 days that that was the only page from that material that was tendered. Then document 290, which is our friends' comments on transcript references and submissions. There's only a few things that I wanted to say by way of response to those. In the fourth dot point relating to paragraph 7.16, it said that we have made no reference to any evidence in support of our assertion that the two pink lines reflected the running and backing edges of the fire when she first saw it. I think we had provided references elsewhere in the document, Your Honour. In any event, they are at transcript 457, lines 1 to 6, and then the issue was revisited at 477, line 35, through to 481, line 28. The fifth dot point dealing with our paragraph 7.29 asserts that at no stage did Mr. Butler give evidence that there was no fire between the big log and the septic area. We say that the effect of his evidence at...
That he didn't go down there because there was no reason to, something from which an inference can be drawn.
Exactly so, Your Honour. And the transcript references are 154, line 25, and 168, line 21. The next one that I want to comment on is the dot point responding to our paragraph 11.32. It said that Mr. Robinson in his police interview and at a couple of points in the transcript clearly states that the area of the big log had burnt when he first got there. With respect, that is not correct. Mr. Robinson in his statement to the police, Court Book document 54 at Court Book page 0127, at about 0.3 through to 0.5 of the page makes clear that the area that had burnt when he first arrived at the property was what he called the island, that is that triangular area of trees and bush between the gentle driveway and the steep driveway. And transcript page 621 at lines 10 through to 26 also do not stand for the proposition that our friends advance. Their response to our paragraph 9.5, they contend that it was obvious from Mr Gilmore's report of the 9th of May that progress of the fire was very much an issue. With respect, the only thing that was clear from Mr Gilmore's report of the 9th of May was that there was an issue regarding fire direction within the area of origin, not more generally. Their comment in response to our paragraphs 11.22 and 144, sorry, 11.144, where we had complained that there were things not put to Mr Bones or Mr Walkley regarding suggested errors as to the area of fire origin, or that there were deficiencies in their path of reasoning. Certainly in circumstances where the witnesses gave their evidence orally, we say that there was an obligation on our friends to put those propositions squarely to the witnesses so that they had an opportunity to respond. I've already dealt with their response to our 11.34 and Dr Marsden Smedley's GPS waypoints. Don't need to, we've dealt elsewhere with the responses to our 11.35. Their comment in relation to our 11.36 and the issue of the SAGs or the tussocks, they say that it's a critical question. Your Honour, with respect, we actually are not at all sure that it's a critical question because the fire scene investigators identified the area within the tape simply as the area of confusion. We respectfully disagree with the submissions as to what the pleading obligations were in paragraphs 11.172 and 173. And the last comment from our friends in response to our 11.195 and 11.206, again, with respect, we say that our friends needed to go further with Constable Hall than they did. It is not enough to put to a witness an earlier recording and ask if he accepts that there's a difference between a fire front and a spot fire, and then not go on to put to the witness that he was wrong in the evidence that he gave to Your Honour, that what he saw at Gangels Road was a spot fire. Our friends pulled their punches in that regard, and Brown and Dunn point does arise. Unless there's anything else on which I can assist Your Honour, those are the closing addresses for the plaintiffs.
There's one matter, and that's this. In general terms, and I'm not purporting to quote you, in your submissions you say...
I'm sorry, Your Honour.
Yes, okay.
You're broken up again.
It's a question of looking at you and talking to the microphone at the same time. I'm not purporting to quote you, but in general terms, in your written submissions, you say that similar considerations apply to the apportionment between Ms Barrett and Mr Robinson as concurrent wrongdoers in the event that there is no non-delegable breach, and as arise as between them as joint tortfeasors in nuisance. I think that puts fairly your submission, doesn't it?
Yes, Your Honour.
Same sorts of considerations apply. The question I have is, in so far as nuisance is concerned and the Wrongs Act, are there any different considerations to those that exist, if they do exist, in relation to the Civil Liability Act?
Just
let me amplify that one whit further. the relationship between them in negligence is that of occupier and invitee or licensee. The relationship is the same in terms of the cause of action in nuisance, save, of course, the impact of that relationship might be different given Ms. Barrett is the landowner and occupier of the land, and Mr. Robinson merely comes on there as her guest, if you like.
Yes, Your Honour, we certainly considered that. In circumstances where a licensee or an invitee onto land can be liable in nuisance for the consequences that spread off onto other lands, it seems to us that it's hard to see a basis for distinguishing the proportions, as it were, under either the negligence limb or the nuisance limb. In each instance, the essential relationship should be characterised the same way. It's a landowner and an invitee, or an occupier and an invitee. For the purposes of non-delegable duty, the circumstances mean that Ms. Barrett remains responsible for the consequences of the conduct of Mr. Robinson, because she did not exercise reasonable care to supervise his conduct in circumstances where she had an obligation to do so. But it may be apportionable, subject to what we had to say about Section 3, capital C. And on the other hand, in nuisance, she's the landowner, she's the primary person who would owe the duty, she's the primary person who would be regarded as responsible for things escaping from her property and damaging other property. But given that Mr. Robinson, as an invitee, can also be liable in nuisance, we couldn't see a reason why there would be a basis for a different prorating of liability in nuisance compared to the other.
So, save that in nuisance, you look at the situation from the plaintiff's perspective.
Yes, Your Honour. Except,
why might it not be arguable, in broad general terms, that if two people jointly commit the tort of nuisance in circumstances such as we have here, because of the nature of the tort and default considerations, their liability is equal?
I see. For this reason, Your Honour, the circumstance that Ms. Barrett was the occupier and he was the invitee is not something that exists only for the purposes of negligence. It's a description of the factual reality. She was the host, he was the guest. He did something with her permission on her property, and in circumstances where she could have directed him not to do it or to do it differently. And so, because the underlying fact of I'll use the word relationship, is the same, we would contend that the impact that's ultimately suffered by the plaintiffs, when one comes to ask for what are the equitable proportions in which the two defendants ought to bear liability, that assessment of what is just and equitable still needs to take into account that underlying factual relationship between two defendants.
But you're not regarding that issue from the plaintiff's perspective as between the plaintiff and the joint tortfeasors. You're regarding it as between the joint tortfeasors.
When one then
as to what's just and equitable.
Yes, yes. When one's working out what the allocation between the defendants is, it's actually almost expressed as the same test for concurrent wrongdoing as it is for contribution.
Mm.
So I can understand certainly why Your Honour wonders whether the fact that nuisance looks at things from the perspective of the plaintiff might lead to a default assumption of a 50-50 split. But that's not the only lens through which the contribution provisions are looked at.
Well, the concept of coherence in the law probably militates against such an approach in any event, that whether it's apportionment between concurrent wrongdoers or contribution between joint tortfeasors, the considerations ought to be the same.
Yeah.
Otherwise, it could lead to anomalous results depending on how the case was pleaded. So.
Yes. Now, anomalous results depending on how a case is pleaded is not unheard of, obviously.
No, well, that's what's thrown up in Woodhouse and Fitzgerald, clearly. So.
That's right. Yes. Yeah, very much so. And the issue here as well, not to overlook the point that we make about the operation of Section 3C and the way that might actually mean that if the duty is non-delegable, then the practical consequence is that it's neither apportionable nor subject to contribution.
Well, that's why I don't want to open this envelope until after everything's done and dusted.
Yeah.
All right, thanks, Mr. Armstrong. Mr. Reid.
Yes, thank you, Your Honour. The issue of warmth in the stump on the 6th,
Yep.
the learned friend submitted there was no evidence that the stump was impacted by fire on the 3rd. There are 3 pieces of evidence capable of the inference, if not direct evidence. The first is Barrett's interview with the police on the 5th, when referring to the pit, she said the fire had come back around there. That's at page 14 of that interview. It's Court Book 58 with the Bates numbering finishing at 0176. Sorry?
Yeah.
It's the interview on the 7th. I'm sorry, it's the interview on the 7th, not the 5th.
Yes.
The second is Barrett at transcript 436, where she said the fire had crawled past the pit a bit.
Uh-huh.
And the third is Robinson's evidence that the stump looked quite different. Transcript 619 and going over to 20, 620.
Yes, thank you.
The only other matter is the submission a learned friend made that Robinson did something with her permission. Now, there's no direct evidence of that it was with permission. The highest it gets is that she handed him the lighter.
Oh. You want to run that over the road?
Oh, over there. Oh, well. No, I wouldn't. If it please.
Yes. All right, thanks. Okay, there's nothing further for me to do then, but to say that I will give a decision in this matter at 9:30 on Friday, the 2nd of July.
Please.
Sorry, Your Honour broke up again then. I think Your Honour saying there's nothing left to do but give a decision.
Yes, I'll extemp it right now, as they might do in Sydney. On, what did I say? Friday, the 2nd of July at 9:30 a.m.
Thank you, Your Honour. Your Honour, may I make say one final thing before Your Honour retires?
We are both away then.
That's this. Just on behalf of the plaintiffs, we'd like to express our deep appreciation for the assistance that Your Honour's staff have provided to all of the parties in the conduct of this proceeding, and can extend our thanks as well to Ms. Marr and Mr. Hawley within the court's registry for the assistance that they've provided in liaising with the parties in terms of setting up this electronic trial, both generally and making today's virtual appearance possible. The trial, may we say, has run wonderfully smoothly, and we're very grateful to Your Honour and Your Honour's staff and the court staff for having made it work so well.
Thank you very much, Mr. Armstrong. I'll make sure that those words are passed on to the Chief Justice and to the Registrar of the Court. I'll adjourn.
All stand, please. This honourable court now stands adjourned.
Thank you.